legal workshop. And I'd like to thank ANM Global for this. I'd like to invite Nitish, he's a charter member. I'd like to invite him and introduce himself and his team and ANM Global.
Good morning, guys. Thank you so much for coming in. I know it's not been easy in the morning to come for a boring legal session. Trust me, the lawyers are anyways treated as boring. So we'll make this session quite interesting for you guys. So I'm a charter member of TIE, founder and managing partner of my law firm. So we normally do these sessions quite often, and we do it for early stage startups. It is not for startups who have raised CCDs and DCDs or DCDs funding for themselves anyway. So in this session, we break this session into a number of aspects. Here I have my two colleagues, Ravini and Rahul, Ravini will take you through the basic aspects of what a founder or founders or the company needs to do while they operate and while they do early stage angel investments and all. She also highlights some of the budget related issues to start with, which is how to pay according to me. Rahul will take you through the IP stuff, and then we'll have a Q&A session. We normally do it in a more interactive way, so if you have questions, we will also be more than happy to address that all more together. Thank you so much, and Ravini, over to you. So we can start. Please mind it, guys, this is the concept and the very fundamentals of startups that we're going to address, because we have planned it for early stage startups. Thank you.
Thanks, Suresh, and good morning, everyone. It's lovely to meet all of you and have the chance of interacting with you over breakfast. And yeah, thanks for making it available. Like Nitish said, we are going to touch on basics for startups and what a founder needs to, as a safety net to get started. When you step out of your maybe the company that you've been working for, when you get the courage to start something on your own, what it means. But as today's session is not just about starting a business per se, it is focusing on startups, right? So I would like to...
Thank you. I would like to get some basics clarified here. For instance, when we, all of us talk about startups very regularly, but let's understand what really a startup is and how is a startup different from another business, right? All right. So first and foremost, we've got, let's understand that a startup is not really distinct from another company, right? A startup also has a business which relates to a product, process, or service. A startup also has its founders, its team, it markets just like any other company. What really sets it apart is that it has a challenge in the sense that it needs to compact everything in a very short span of time with limited resources. So a startup additionally has either an idea which is novel, or it has some kind of a solution which the market does not already have, which may not necessarily be considered an innovation as such, but it is a solution. Say for instance, a solution of, say for example, Swiggy, right? Swiggy found a wonderful solution of supplying not just food but also Swiggy Genie, which all of us use so extensively. It may not be considered as an innovation because you have had other people who've come up with this solution, but Swiggy's come up with a feasible solution, and that does amount to a startup business model, right? We do have structures, we do have regulations for startups, and most importantly, we have a government that really understands the importance of a startup. The government recognizes that with the population that we are today, we can't possibly have companies generating employment for the world, at least for the country, right? So what the government has been trying to focus on is to have a lot more startups that can generate jobs for themselves and generate business, of course, in the process. That is what the government's interest has been, and which is why we have a lot many benefits associated to startups. And the regulatory burdens, etc., which a normal company would have been slacked off for startups, at least in their initial phase. Going back to the definition of what really amounts to a startup is, it has a certain timeline. So a company which is under the age of 10 years and having turnover under 100 crores. These are the basic requirements of what can make a company eligible to be considered as a startup. Beyond that, you do have a certification that's called the DPIIT certification, which you must apply for, because it's the benefits again that a startup needs to apply for. With these for these benefits, you need to be a startup certified company. In order to be eligible, you also have to have certain kind of corporate structures, which we'll be touching upon in detail. You need to be either a partnership, an LLP, or a company at large, and that makes you eligible to apply for DPIIT. It's not that sole proprietorship cannot be considered as a startup by the basic understanding of a startup. But getting the startup certification becomes difficult in that situation, which is why for a formal startup you need to be either a partnership, an LLP, or PVT Ltd, and that makes you eligible for the DPIIT certificate, which will make you eligible for a lot more benefits. And these benefits include grants, they include slacking off of regulatory burdens, and also it makes you eligible to enter into a lot of government options, lot of not just investments but also your funding groups which target startups per se. Yeah. 1 second, I think we've got a slide further. Yeah. So just to quickly review, we've covered the benefits, the eligibilities, the requirements, and now we are heading to a quick understanding of the various stages that any startup requires, right, or goes through at large. A lot of you here are still at the ideation stage. I like to see startups as a very when you say the seed stage, etc. So it really speaking in a literal sense, it's like you've sown a seed, and it's how you literally nurture the whole plant that your plant really grows into a beautiful fruiting plant, and that's really all out here. So starting from your ideation, you have an idea, and it's not yet in a product form, it's not manifested. That is your ideation stage. At this stage, you've probably got a business model at best. When you take this business model, you look around for your partners, you look around for a team who is soon to join. Very often you have a soft binding with this team who will eventually join once your funding comes in. And that funding comes in at the seed stage. When you've had a sure model in place, you've spoken to your probably mentors, you've spoken to interested investors who typically at this stage are friends and family. It's your inner circle, because at this stage you're really being trusted by people who know you and who know your ability to grow a business, right? So that's pretty much the seed stage. A seed stage at best goes into the market, and that's where you can actually show the progress of your idea, right? The reality of your idea. How well does the market accept this idea, and what is the profit that you have generated with simply your idea at that stage, right? From the seed stage, as the market grows, you enter the funding rounds, right? This is where the real game begins. You have had your small team, you have had your idea, you have seen the idea come to reality, and now you're ready for the big game, and that is where the funding rounds begin. And of course, after that you diversify, you scale up, and that's where your expansion goes. Right? Throughout all of these stages, what becomes important is your foundation. When typically a startup comes out, the largest challenge I see is courage. Courage to really have the right idea, whether you have the right idea or not. If you do you have the right people to go into the market with that idea or not? And very often, this courage is kind of given by people around you. And that often leads to having co-founders who are friends or family. That's what makes the founders agreement so important. Entering into a business with friend or family, as all of you I'm sure would agree here, can be very complicated, right? And should things, of course, there are some, who have till date not entered into a formal binding and are still at a, a well-to-do stage. But those are very rare cases. At most times, what you need is a formal binding, so things are clearly mentioned on that piece of paper, not just for the relation between you both, but as we saw in the previous stage, where you are inviting third parties to invest in your company. How do they know, how do they trust the relation that you both have? When co-founders have a falling out, what really happens to the company? That is a risk factor. And to overcome that risk factor, you need to have certain formalities in place, such as your founders agreement, that reassures your investors. Apart from all the other requirements which you yourselves will need amongst yourselves, right? With that, another important point comes to mind, which is the incorporation. How and when do you really incorporate? And how complicated is it to incorporate? We've already touched upon the kind of incorporations which make sense for startups, especially for the certification. The choice of incorporation greatly depends on some of these factors here. Number one is actually your risk. So, do you want to be a separate legal entity to mitigate that risk? Listing of shares becomes important when you are considering an investor. When an investor comes to offer you the funds, it's best to have shares to give them. Beyond that, you're going to be offering a partnership, right? So you're going to be offering a larger stake into your company without clear, simplified agreements that a shareholders agreement can offer. Which is why it is often preferred to have your share structure in place before you are talking to third-party investors. Capital contribution, of course, becomes easier with a formally incorporated company, and administrative burdens is a major one that becomes a deciding factor in choosing the kind of incorporation. If you are a low-risk company, your business model is low risk, then having a simple partnership works. It works quite fine. If you are expecting foreign investment, or if you have a partner who is, foreign national, it makes sense to convert that to have an LLP. If you are a high risk, it makes sense to have a PBT, LTD. There are lots of other reasons that help in deciding the choice of incorporation, but this example is just so you understand the parameters to consider when selecting, one of the incorporations. It's not simply because of administrative burden that you choose a simpler form of incorporation. It's actually the journey of your startup and the stage at which you are at, which should decide and of course the nature of business, which should decide what kind of incorporation you would like. Now, we are happy to share our PPT, and this table is a very detailed table which lists out the different regulations that come into place, the timelines associated, the basic minimum number of partners required or directors required for such incorporations, and you can study it at your own time. I won't bore you with the details at this point. Beyond the founders agreement, what we realize is when the startup really gets going with the business, especially around the seed stage time, it has to outsource plenty. It has a lot of vendors, it has a lot of contractors, it has a lot of third-party involvement, and if there is an innovation involved, if there is a confidentiality involved, that's when you definitely need a non-disclosure agreement before you get into any dealings. Even before you discuss the business model of whether or not you are getting into the business, you need to upfront share the NDA, as we call it, before any further talks. And of course, when it comes to your vendors or contractors who very often make the prototype at the initial stage and later might even take on the entire contract of manufacturing for you, that's when you need a more advanced agreement beyond a simple NDA. This typically is called a vendor's agreement, and the vendor's agreement will have lots of clauses involved, such as a non-compete, and a lot of facilitators have tried off the 20 lakh rupee grant. Some of them are still running green, and that's an option. But an alternative option, also an option that I personally prefer, is a 50 lakh rupee grant, not because of its value, but because, and also this is not with no strings attached. It is an investment. It's a convertible instrument. CCD is the typical mode of this particular equity, and this is the mode for SISF. And with this grant, you have a slow release, you have milestones, you have a due diligence, you've covered a lot of basics before entering into the markets to receive further investments and funds. So, and with this grant, and the value is pretty fair. They do look at your valuation and thereafter invest the said amount at that value of your company. They don't often negotiate hard and strong on your valuation. They've all got the pressure to release their grants. So they look at your valuation. If they see that your valuation is pretty fair and honest, it doesn't take too long to get the grant going. But therefore, you need to be very honest about your valuation, right? So you need to know that they know what they're doing. So make sure when you project to such grants, you have a fair presentation of your own. But this kind of a grant you're not eligible for it if you've already been funded earlier, or if you've been a startup for more than 2 years, incorporated more than 2 years. So that kind of is the eligibility criteria. So for instance, if you've got a BIRAC, you can't really get this. But if you get this, and then you apply the BIRAC, you can get 50 plus 50, right? So there is a strategy when it comes to grants and when it comes to funds, and that is something to look at before you just blindly apply and accept for any approvals. There are also state-specific grants. These are lower in value, but they are great add-ons to central. And you can simultaneously apply for a state and center, and they will not, override the other. State grants have been great for IP filings. International patent filings can cost up to 15 lakh rupees, and the state grants alone can cover that really well. So and you have specific IP filing grants, which are also wonderful to have, and that really, reduces the financial burden because IP protection, as Rahul will explain, is so important for a startup, because how do you sell something that is not really your own? And how do you own something without filing an IP? Because a core of a business is either a product, process, or service. And the only law that protects a product, process, or service is your IP, right? So owning your business is definitely very important for a startup. Finally, just to give you the key highlights of the budget, I'm happy to announce that the government is still very much supporting the startup ecosystem, and you can see the tax holiday, which has been, I don't know if any of you are aware of the tax holiday system that startups have. Yeah. So the tax holiday, just for the rest of you, is a no tax requirement for a period of 3 years. You can choose which 3 years you like out of the 10 years. It's your choice. But now this was applicable for startups who had incorporated up to 2023. This has now been extended to March 24. So all of the upcoming startups will also be extended. And we are hoping that this extension will continue for a couple more years, because this has happened twice already. And as in the extension has happened twice already. So that's one good news. The second is the carry forward and setting off of losses, which earlier was possible for 7 years. So you could set off your losses, within the 7-year period. And now it has been extended to 10. The logic or the mindset behind this would be that initially startups were considered for 7 years, which was extended to 10. So therefore now even the carry forward has been extended to 10. Yeah. And beyond that, they have, of course, the National Data Governance Policy. A lot have been confused about this and the data policy. And these are two different things. Data policy is more about the personal data and how to manage or handle and store, sell or transfer such data. This is for non-personal. This is especially for startups and researchers and how to access data anonymously, and this is more for R&D. This is for how how to innovate better, how to research further, how to have access to data. So government has opened a lot of its data sources by this policy here, open for us to research upon. The point number 4 is very, very important. I don't know if we have any startups from the agri or the green growths. Yes, I see you nodding.
I have a friend.
Perfect. And also AI. Okay, fantastic. So all of you here are looking at a very strong support from the government here. As you can see, there is 20 lakh crore target set aside for agri startups, and a lot of other support systems as well. So following the budget comes schemes, and these schemes are they focus on what funds will be allocated for which schemes, and those details will follow a bit later. But we have a clear idea that these are the 3 that the government is very closely looking at. And having said that, there are lots of other support systems as well. Say, for example, an accelerator fund specifically for agri startups. This is something which really targets the agri startup world, and that entire ecosystem is looking to boom up in the next few years. Also, the green growth policies, programs, a lot of funds as well. Everything around green growth. We've been seeing so many, EVs. We've been seeing so many, biofuel companies coming up, and these will be supported by the green growth focus of the budget. And of course, AI. There is so much happening in the AI field currently, and that will continue to happen. And we will see a lot of support from the government in setting up infrastructure places as well, because I think infrastructure is one very important requirement of startups. We do have one startup in the AI field, and all he needs is a lab, right? All he needs is the lab. He has the brains, he has the funding as well. He has a team also, but he can't invest, because that will be more than 50% of his funds into a whole lab to research upon his prototype. Because what's going to happen with the fund that goes into the research of the prototype? You won't need that lab anymore after the prototype is made. So that is how the infrastructure support is going to really help the startups today. And yeah, so that's a quick review of the budget. And happy to take your questions after Rahul's session. Anything about, we can even discuss in the networking round. Over to you, Rahul.
Thanks, Agni, for the wonderful session. And great to be here and dressed formally at a party place. Thank you, everyone, to be here, and good to see smiling faces in the morning. So I'm Rahul. I take care of the dispute resolution IP practice at the firm. So normally at this time I am normally in the board wearing a gown, but today, since the session is there, I have to be here. Thank you, Ty, for always fostering entrepreneurship, and I think with proper mentorship, any startup can be so-called unicorn. I actually don't like that word. I like the word cockroach rather than unicorn, because I always say this, that you should be able to survive, and the person or the startup who survives or believes in their idea really makes it. Unicorn these days is a bubble. So before we discuss any strategies, the startup should first believe in themselves and the co-founders that they are the only person with or without funding that can really make it. Don't focus too much on the term sheet, don't get obsessed by it or the funding. If you believe in the idea and really know how to scale it up, funding will come. So don't focus too much on that. Another thing is idea. Idea should address some pain point and just not filling up a gap. There are already 10 in the market, so your startup can also be successful. It's not that. You should identify the gray area, have some product differentiation, have some different kind of UI, UX, register the IP, protect the IP so that you can be distinguished from the competitors. You should have a good team, search for good co-founders who you can trust, okay, because IP or legal can only support you if the environment is good amongst your startup, and you as a co-founder or a founder believes in the idea. Then only IP can actually help you achieve whatever goals that you want to achieve. Then of course, business scale of business, whether you are addressing 1 million users or you are only addressing or focusing on a luxury segment, or you are focusing on reaching volumes, 100 million users. Accordingly, you have to structure your business and also structure it legally accordingly. Then timing is also one of the crucial aspects that we have seen in COVID. Startups from lung abnormalities that we have actually filed a lot of patents around it. EduTech, then EVs, all these have come up because the timing was right. So that's also one of the important aspects that you have to. Why I'm telling you this is before we jump into legal strategies, these are the core principles on which is outside the legal ambit, but at the same time also important for a legal and business to help you achieve your desired goals. So focus on the short point is focus on value and not valuation is what I was trying to say. So yeah, to start off, I will be addressing So it's a large, in the sense, subject to cover, but I will touch upon some important aspects so far as essential ingredients of IP is concerned, vis-a-vis a startup. So essentially there are three kind of startups. One is a trading based or a manufacturing based startup. So how do we protect the IP in such kind of startup? Is by way of agreements, transactions, and the trademark. So when there is a manufacturing setup, you should have agreements with the vendors, the person that who's giving you the orders, if you have to export or import, or have some kind of transaction, the POs that you receive. In that you need to protect your IP on transaction. You should know if somebody else is owning the IP, then accordingly transactions, or you should protect your legal rights. If you are owning the IP, then the transaction is the only way that you can really protect it, because you are not an innovation based company, you are just a manufacturing company. You are providing your services. So indemnity, warranties, IPs, all these have to be taken care of. Secondly, innovation based company, that is core to IP, where IP is the most essential ingredient so far as establishment is concerned. So you should identify first. Identification of what exactly is the IP, what is your differentiation, the trademark, if it's a technical aspect and patents, then if it's a product, if you are into plastics or into jewelry or textiles, then designs. You should identify the IP, file it, and then start the manufacturing process. Then the enforcement, again very important. Just by protection is not the end of the story. You should also be able to enforce it. Enforcement can be by way of having foolproof agreements and also enforcing in the court of law, so that your IP is not diluted. If your IP is diluted, then there will not be any deterrent in the market, and people will start using. So I'll just give an example. We are actually doing a design litigation, where it's relating to textile, and there are a set of proprietors who create a design so far as sarees is concerned, and then somebody else starts using it, and it's a process. It's a very normal process. Nobody is aware of it. There is a proprietor who files for a design, and then there are 40 manufacturers just copying the next week, and the shelf life is very small. It's like within 6 months or 7 months, the cycle of the entire IP is done away with. You have to come up with different design because people get bored of it. Okay, so if you don't protect it, then there will not be a deterrent effect. Whatever you do, you protect your IP. You have a design registration, you have a trademark registration. Somebody else is using it. If you don't stop that guy, or you don't set an example in the market, then your IP will get diluted. There is no point of just having an IP on paper. You need to enforce it with proper channels. Okay, we have to also take care of the resources and the monies that you have, and then accordingly take a decision. But it has to be taken, otherwise, and at the right stage. Otherwise, it gets Bisleri, even despite being such a big company, there is, now they are aware and now taking action. Xerox, people are just using Xerox as a very generic term, but it's a trademark. Okay, photocopy is a generic term, not Xerox. So they did not take actions. It was used in media, it was used in newspapers, it was loosely spoken about, and no action was taken. And then there were repercussions and dilution of brand. So very important to enforce. So identify, protect, and enforce so far as innovation-based company is concerned. Third is again a service-based company. If there is a software-based company, if you are on a work for hire, then proper agreements. If you have to basically develop a software, for example, there should be. I was just discussing it with someone in the morning. There has to be a proper service agreement where you engage and take the IP with you. Okay, if you don't have that, then the software guy would be the first owner of that particular IP. Okay, and then he can exploit it in whichever way. He can sell it, he can make use of that IP and also earn money. It's a work for hire. So you have to have a proper work for hire agreement with properly drafted IP clauses, where there is a assignment, specific assignment from the software developer to you. So wherever there are service-based industries, such contracts, work for hire contracts, even for manufacturing sector, are very, very important. So quickly, before going to the essentials of IP, basic differentiation of what exactly different types of IP are. So first is a trademark, is a source identifier. Okay, it can be a logo, it can be a name, it can be a numerical, it can be a shape as a mark which is distinctive. So for example, the old monk bottle, the laughing Buddha bottle, it's very distinctive. It has attained distinction over the course of many years. It has become a source identifier. So that is how shape becomes a source identifier. It can be registered as a mark also, along with the logo, or like Amul. Amul has the ladies, the girl, along with, that is the device, along with the word Amul. So the entire label can be a subject matter of trademark. Now 555, again the 555 is a subject matter of trademark. There are labels, several elements in a logo that can be a trademark. Okay, slogans, phrases cannot be a trademark. Okay, because it's descriptive, generic. Unless it has become so distinctive through use, like just do it. Nike, just do it. It has become distinctive through use. People associate just do it with Nike alone. Then it can be a subject matter of trademark, but that is after the use, not at the time of application. At time of application, it will be rejected, to be very frank. So there is a detailed examination process when you adopt a trademark. It goes to the registry, examination is conducted, examination report is generated, you have to reply, you have to then appear before the examiner and prove that your trademark is distinctive and get it registered. And you can use it. It's not necessary that you first file and use it. You can start using it and then also file it with a user affidavit or claim of user that you are using from 2010 or 12, whatever. But you have to produce proper evidence that you are using from so and so date. What happens is many of the startups or companies, they don't preserve documentation of user. So if they have a logo, they don't really have that logo on the invoices for that matter. It becomes a evidence for showing use of that particular mark from so and so date. So it's very important to preserve such kind of evidence. Second is patent. Patent is, so for example, technicalities. Whatever technology is involved in a product is the subject matter of patents. Then comes the design. Design is only and only the design elements or aesthetic elements of a product which appeals to an eye or solely judged by an eye. No functionality involved. Functionality becomes the subject matter of the patent because there is a technicality or technology involved. So shape of a particular product, like Apple Mobile has a certain shape. There was obviously litigation that people have copied that particular design, and Samsung, Apple is a famous case that has happened in different jurisdictions. But that is a subject matter of design. What is in the mobile is a subject matter of patent. Touch to zoom, pinch to zoom is subject matter of patent. Then comes the copyright, literary, artistic work, scripts, literary work, songs, lyrics, literary work. Artistic work is what you draw, whatever artistic element, painting or anything artistic. Can be a logo also. Logo has different kind of artistic element. Then dramatic work, whatever performance that is being held on the stage is again dramatic. Even sound recording, musical work, cinematograph film. Cinematograph film is again embodiment of all the underlying works that are there. Sound recording and lyrics and everything combined together is a subject matter of a film. So these are the essential elements of our subject matter or different types of IP. So I hope everybody is clear on different types of IP. Then IP availability check. So before adopting any IP, except trademark, which I've given an example of, but it's always better to, if you are adopting a distinctive mark, okay, it's always better that before adopting a mark, you conduct a thorough check. So you can get in touch with the advisor, or you can do it yourself through government portal, that is ip.india, ipindia.nic.in, which is a government website where you can conduct a search yourself in the relevant class. So for example, if it is a food related class, like class 29, or pharma related class, class 5, okay, you can select that class contains the word whatever, and then conduct a search yourself. You will see the conflicting mark. So if there is a very similar mark, you should not adopt that. And you should adopt, because then you will see that these conflicting marks will be cited by the examiner, and your mark will not be passed further. So it's always better to adopt a distinctive mark. Now what is a distinctive mark? There are marks like Jabong, Myntra, does not make any sense at all. They are the strongest marks. Generic marks are booking.com, shadi.com. They are generic marks. They got the registration through use, but they are inherently a very descriptive mark. Super cup, then toothpaste for toothpaste. All these are non-distinctive marks, will not be registered in the first book. You need to adopt marks which are very, very distinctive, and for that, to find out that if there is any similar mark, you need to conduct a thorough check and then adopt it. If there is any similar marks, then you can tweak the marks. So for example, there was one client who came to me, he was into repairing mobiles, and he said that repair mobile is the mark that I want to use. I said that boss, you cannot use it, it will be rejected. He said that I want a repair in my this thing because I can communicate that idea. So that's also important for a startup to communicate their business idea to the consumers or customers. For that, then we conducted a search and we came up with the idea, why don't you adopt repair X in a logo form. So let's first file a logo application, let it be accepted or registered, and then we'll file a word application. Okay, so that what happens is, in a logo there are several kind of artistic elements. Okay, so it's not just repair X, it's also the artistic element, the font, the color, the way it is, combined together. Repair X, X is big, X is small. Okay, so first we find the logo application, it got registered, and then we find the word application, basis the registration of a logo. Okay, so these are the different strategies that we adopt, basis the requirement, of the client or anyone who wants to seek registration, get a solution to or communication of that idea to the customers. Bharat Pay for that matter. Again, a very, very descriptive mark, but it got registration through use. So all these are situations where it's a part of discussion what exactly you want to do, and then you should definitely then seek advice to find solutions to the problem that you wanted to solve. So it's a prerequisite to conduct a search before filing any kind of IPs, be it trademark, be it design, be it patent. Patent is very, very necessary to conduct a prior art search. You cannot just file a patent application before conducting a prior art search. So there are various kind of tools which are available. There are Google patents also that are there, the publicly available tools, or you seek advice again where this particular patent, if there is anything similar anywhere around the world, can be compared. Then there is a discussion between the attorney, patent attorney, and the client that what exactly is there really a similarity. If something should be tweaked on paper to really get the patent registered, that has to be discussed and solutions should be found, and accordingly the PS or CS should be drafted and filed. So far as patent is concerned. Then copyright is something which it is not mandatory to register a copyright, but the moment you create it, artistic work or literary work or anything, automatically you get a copy. Okay, but you need to publish it to show that it is your work. So if you have written a book, you should publish it. Okay, then there is written that it is published on so and so date, copyright so and so, so that if somebody else tries to copy it, then you can always produce this before the court and your date of creation was 2020 and when it was infringed was 2022. There is definitely a dishonesty and it's a copyright infringement. So movies and all, we don't file a copyright registration form. The moment it is published, it becomes my copyright. The moment book is published, it becomes my copyright. Yes, for labels, the artistic labels like Amul that I given an example of, you should register a copyright, because if you have to catch hold of any counterfeit activity around the labels, especially in nutraceutical industry, pharma industry, food industry, it is very necessary that the label should be also applied for a copyright, because it gives you a remedy, criminal remedy. Under section 63 of the Copyright Act, you can really file a private complaint, get the registered FIR registered and catch the guy, arrest the person or raid the premises. So it's a very, as a part of strategy, it makes sense in this situation to register a copyright, and it has to be done anyways in so far as these industries are concerned. Then coming to yes, so copyright check. Yeah, I have just discussed copyright check. So I also wanted to explain you the difference between what is available to public and what has gone to public domain. So what happens is copyright. Normally the term of a copyright is 60 years from the death of the author. So once the author dies after 60 years, it goes to the public domain. So you are free to use it. There is no copyright for it. Versus what is available in public. So some people think that whatever is Googleable or whatever appears on internet can be used without any interference. No. It is a subject matter of copyright of someone else. You need to check it and then use it. You cannot just pick up images and use it on the website or use it for your promotional or marketing activities. It will amount to infringement and they can sue you if they want to. You can definitely, you cannot just pick up somebody's, the traffic was diverted to shadi.com and there was second shadi.com. Okay, all these were, so they were all injuncted and all that, the domain name was rejected, it was deleted, transferred or whatever. Now in fact, there are orders of the court where the domain name registrar has been directed not to allow similar marks to be available for public. So for example, Swiggy got an order against GoDaddy, directing GoDaddy that why are you providing similar Swiggy marks to the public for them to use or create a website. You should not do that. This is the first landmark decision so far as directions are concerned.
So it's very interesting you say that, because now you've got so many different TLDs coming up, .tv, .org, .com, .co. So how
so
can
that doesn't make a difference. So .co, .in, whatever is again just an extension of the primary mark, that is shadi.com or in. Doesn't make a difference. You need to see the similar. The court will first see the similar. That's it. If it is similar and the activities of the defendant are dishonest, then you will not get you will be injuncted basically. Defendant will be injuncted. There was a case also in the same shadi.com case. I don't remember the defendant, but the court said that the guy was not dishonest. Okay, the defendant was not dishonest. It was communication of his business idea and you cannot claim a monopoly on Shadi. He was using Shadi something.com, not just Shadi. Shadi was not a predominant factor alone. Shadi matrimony or something.com. So the court said, and it is an appeal, obviously. It will be adjudicated again in the appeal court. We as lawyers, we like to file appeal if we don't get a favorable relief. But yeah, having said that, you should be on the safer side, and a domain name search, thorough search has to be taken, and you cannot just adopt confusingly similar mark or deceptively similar mark as a part of domain name. Global IP strategy. So if you want to go international with your product, especially for patents, you should do it before launching the product globally. You should sit and create a strategy, global strategy. What are the targets? What are the territories that you are looking for? If you are looking for US territories, then you should enter the national phase application. At least the application should be in process so that then you can start manufacturing. If there is African countries, Gulf countries, or EU, US, whatever. So a global strategy has to be developed if it is related to design or patents. So far as trademark is concerned, you can start doing it and then later on file it, because what happens is if you don't file it, somebody else will file it, and then it happens in China all the time. So we were representing Bajaj and some Chinese guy with a Chinese name filed for Bajaj, and then he said that it's my personal name. So he was selling counterfeit products, and Chinese environment is such that they promote counterfeit. So it's better to, in such territories, file it and then start. But having said that, registration of your brand is also important so far as pharma and nutraceutical and other things are concerned, because on licensing you have to apply for the mark. Otherwise the manufacturer there or distributor there will apply for the mark and get a registration to show that he is a proprietor and start using it without your consent. He'll just start using it, and then the authorities, obviously he is that local guy, so to take an action against him in that territory becomes a problem. But having a prima facie evidence of registration and valid trademark then becomes very important. So understand all this, create a global strategy, and then park your product. Yes. Then I just discussed the timelines and the government fees. The startup costs and grants are discussed by Ragini. So for a trademark also, if you are an MSME company or a startup company, then you are subjected to grant, and in DPIIT if you are registered, then you can, after filing the trademark, you can apply for getting back your professional fee and a government fee which you pay to lawyers. So there is a mechanism, and it works and you get the money back. It's just that you have to channel it into a proper process. Same for trademark, patents, and design. I'm not sure. Design, I don't think we have. Yeah, so design also is there. So
copyright.
Copyright.
How long does it take?
For a copyright, yeah, copyright 6 to 7 months.
Copyright also 6 to 7
Yeah, 6 to 7 months. I don't know if it is not mentioned. Why it is not mentioned, but 6 to 7 months for a copyright. A copyright, like I said, it's only applicable to certain industries where you should really apply for a copyright. But when it comes to publication of big books or movie or media related activity, it's better to publish it. Or if you are not able to publish it, record it in a form of evidence. So if you are a script writer, okay, I understand that if you approach a production house, they will never sign an NDA, okay, or they will never, they will obviously be reluctant. So record in the form of minutes at least, on email, that you have discussed briefly this script on this and this date over the meeting, so that your major idea is recorded in the form of email that was communicated to them on this and this date. If they try to take that idea, create a movie or a series or any OTT, whatever, the movie, then you can approach the court that you are the script writer or whatever you are the author of that particular story, they have copied it. Same applies to any other IP. If there is a patent that you have not applied, okay, you should definitely not disclose it, even if it is an investor, without signing an NDA. Again, it is difficult, but if you can sign an NDA, then it's the best. Otherwise, just record it in a way that it does not disclose. You should really think about how to record that particular idea, that it is communicated, that is on this date you have been informed about this. Yeah. Then scaling up. So first, after your protection and search, the next jump, and after you get all the funding and the rounds that Ragini discussed, how to use IP as a tool to scale up your business activities is again very important. So that can be by way of licensing, assignment, franchising. There are so many food brands or food industry where they enter into licensing or franchisee arrangement, and then they earn royalties. There are franchise agreements, there are licensing. So many companies that have a big portfolio of IP. There are many patents which are just lying dead. They're just on paper. But then what they do, they cannot manufacture it because there is a lot of cost involved. What they do is they license and earn money out of it. So there are many patents, for example, pinch to zoom, touch to zoom, are used by all the mobiles. So it's a technology which is licensed or owned by Apple and Samsung also. So it is licensed to all other mobile companies to use it, and they earn revenue out of it. There are many. So building a good big patent or IP portfolio is again important so far as valuation of that company is concerned, because that will also be helpful for you to value your company. Because if you are an innovation based company and if you approach an investor, and if he, the first question that he will ask you is, okay, this idea that you have, is it protected? Have you protected it? Okay, have you registered it? If you have not applied or registered it, then he will not really fund you or think of even leveraging his resources for your benefit. So that is of paramount importance that you should register it. And then of course for scaling up or using your IP to scale up, licensing, assignment of your IP rights and earning profits out of it is again one of the medium. Acquisitions and portfolio building, as we discussed. Commercialization of it is a part of IP licensing. IP validation is again an exercise. I mean, that's again a part of registration and search process. Due diligence is again if you have a big IP portfolio and you need to really have thorough checks on renewals and maintaining your IP portfolio from time to time. It's very important, because what happens is sometimes the IP expires and you're not even aware. The trademark is abandoned because there was no prosecution. So then it becomes a problem. Then on register you've taken pains to build a brand, and on register it just abandoned because the attorneys or yourself, if you are managing it in-house, were not able to respond to the examination report or some other compliances that are required. So a thorough due diligence and maintenance of IP portfolio is again when you have a proper IP portfolio in place should be done. Enforcement, again, I just gave an example. It helps you to prevent dilution of your IP. Next. Yeah, so this GoPro example, I mean, thanks for having it come up with this GoPro example. It's a perfect. I mean, it's a good example to show how IP can value or devalue your company. So everybody knows GoPro, the camera brand, and it's into sports. Media and camera technology. So when it was launched, it was around 90 USD. It was a GoPro technology, a very fantastic product with a good design and everything. So the components of GoPro, when people got to know that the components of GoPro were already patented by computer technologies like Nikon, Canon, everything, the share value went up, and there was also litigation against them. Okay, so everything was in the public that GoPro is an innovation brand or innovative product brand, a camera brand, without even owning the IP for the product. They should have, if they don't want an IP, they actually should have taken license from these companies. So the share value went down to $2. Okay, then they started building IP around. So once they realized that that company is doomed, then what is the step, because it's an innovation brand, otherwise it's a 10 product 10 company, everything they will have to wrap up their bags and leave. So they build an IP around it. They filed for designs in smaller versions of GoPro, unique designs, design aspects. They went against building their brand GoPro as a brand, okay, because their IP was not registered. So as a brand, they tried to promote it or market it in a bigger way. Okay, try to segment it in sports category. Okay, so they build IP around it on designs or trademarks or licensing aspect. They settle the disputes with all the other companies, and then the share value went up. So what I am trying to communicate is whatever the company or the nature of company is, if you are not protecting your IP, it can doom you or value in such a way, in an exponential manner, that you can achieve really your dreams and whatever objectives that you want to achieve through the scaling up. Yeah, these were the activated technologies, the patent numbers and other things which were then it went up to 14 USD. This is a pretty old number, I think 2021, but I'm sure that now with is not at $2. So yeah, other examples are Darjeeling tea, the most successful GI brand in India. It's the most successful GI brand in India, like Tequila, Champagne, and everyone. They are all brands, geographical indications you can say, and they built an IP around it and really scaled up. And Apple had to buy iPad from third party in China for 60 million USD. So, like I said, just give an example of how Chinese try to file file a counterfeit trademark application in their respective territory. If you don't protect your trademarks in such territories, then somebody else will apply for it, and then ultimately you will have to then buy it, or these are all the tactics used by infringers in such territories. And again, I mean, there was an IP case, Polaroid versus Kodak. Instant camera patent, Kodak lost around $1,000 million. The factory shut down, 1.5 billion manufacturing unit shut down, there were layoffs, and other related aspects of IP. These are the examples where IP is used as a tool to scale up and can break a company. Common mistakes, Ragini already discussed. So co-founders agreement is very important when you are starting at the ideation stage, because what happens is you should not just trust that he's a friend, he's a relative, and whatever. I mean, he's somebody that I know and he will not betray me. Everything has to be in writing, especially IP. IP has to be with the startup. It cannot be with the co-founder or one of the founders, because if he exists, if he doesn't exist, then the IP then is taken away by him if he's the applicant or is the proprietor, and the startup is left with nothing. So it's always all these terms has to be mentioned in the co-founder agreement that the IP will always belong to a startup. If you leave the company or the startup, then everything will come or be owned by the startup and not an individual founder, unless it's a sole proprietary and there are no co-founder, then it's a different story. But yeah, it has to be owned by the startup if you are planning to scale it up, because if somebody leaves with the IP, then again the valuation drops. There is an example of that.
It's freezing. Can you just switch the AC off?
Switch it off.
Please.
Everybody knows the story of Winklevoss brothers with the Facebook. So the idea was them, and they Mark was engaged, or he was supporting the entire idea, and they did not have any agreement, and everything was then there was a fight, and they could only earn $2 billion out of it, and the rest is history. So it's a perfect example of not having a proper co-founder agreement at the initial stage.
Just one question. How did they manage to get this $2 billion?
They filed a case. And they must have showed evidence that there must be some email correspondence. But ultimately, email correspondence they must be having.
Because
Yeah.
most of them sign up or even
Correct.
talk to co-founders.
So there must be some secondary evidence in place for them to really come at that figure, and some corroboratory evidence to support their case. But it was without any agreement or anything. The IP was owned by Mark. Facebook as a company was also registered by no stake was given to them. So it was all done behind the back. So, but the long point short, you should crystallize everything in writing and the arrangement, and it has to be thought thoroughly. Term sheet, like Ragini suggested, has to be discussed before entering into any arrangement with the investors. Don't just give away equities. Everybody is now seeing Shark Tank. Sony is one of our clients, and we get a lot of issues so far as Shark Tank is concerned. But when I see the series, you know that even 1% of your equity is a lot. If you really believe in your idea in the startup, don't just give away equity for money. 1 crore and you take 50% or 60%. Don't do that. 1% is if the product is robust, the market is good, the timing is right, the other factors like I just mentioned, the team, the co-founder is of a different domain, maybe in the marketing, you are in technical, all these aspects are taken care of, then you can really pitch in a good way. But before pitching, obviously the legal hygiene is to be maintained, because these investors will ask you whether everything is in place, the systems are in place or not. Yes, so yeah, quality advisors should be always consulted if you have any doubts, and there are schemes by the government also to support you financially so far as even advisory is concerned, so you should take advantage of that. And yeah, so rest is already discussed, the competitors, and you should know your competition and the IP that they hold, and you should not infringe any other's IP. So all these are important aspects and the common mistakes that happen in the ideation stage, which can be avoided. So thank you everyone. I'm open to questions. Yeah.
Now registered my startup as API.
Yeah.
So another question.
Can you be a bit loud so everyone can hear?
Yeah.
Give me the mic.
I have registered my startup as DPIIT 2 years back, but not clear like what are the compliances which are not applicable. Example, ESIC, PF, BTRC, or is there any specific list which we can refer?
So we just discussed that list, so it has to be discussed in detail, and I
I'll
will be
get it.
assisting you in that.
I'll share them.
We just had a slide on what are the different kind of schemes that are there.
And not schemes actually, which are the compliances for a private limited company which are waived off?
I'll share them.
And one more question for equity. What actually happens if equity is already given and founders split up? Or
Oscar, so what he told is you have to understand one thing. Your founders agreement needs to be in place. If your founders agreement is not there, then this challenge is going to come. What is an equity? It's shares at the end of the day, right? You can't just throw out anybody as a shareholder. So you need to have that. So once your founder leaves, he can hold shares in your company. For that matter of fact, he might sell it to someone else, or you might then agree to buy it back at a fair market value tomorrow in the future. And if you have a founders agreement in place tomorrow, and then he exits, then you can have an exit policy in the founders agreement that if you exit, so tomorrow I should have the first right of refusal to buy it and all that stuff. So a founders agreement will define everything. And if you don't have a founders agreement, then you are stuck with him as a shareholder unless you decide to buy him out and he decides to sell you shares.
Thanks.
You know about the Ashnir Grover case that is going on. So he's left the company and
He is still the shareholder of
Yeah.
Bharat Pay.
Yeah.
He's not out. He's out as a director or the CEO of the company.
Under DPIIT, can we change the concept of whatever we are registered once, or we have to?
The register of companies can be changed from LLP to private limited. Is that right?
Not the registration type. Let's say we are registered as a specific product type or a specific idea. And now we have
The nature
pivoted
of
to a new
business.
idea.
So no, there are group classifications. So if you mention a larger group, then it's better to mention a very broad understanding of your business.
Objectives जो है broad रखी है हमेशा. Always have broad objectives.
So they don't really oppose it. But if you're doing something completely different from what you've mentioned your business does, then yes, there is a problem there. Especially when you opt in for government tenders, which is one of the prime benefits of startup certifications. That's when these things are looked into. So better to, additionally you can have another certificate if you like. You can even apply for a change. Generally changes take time.
So on the same private limited company, I can have one more DPIIT.
No.
I do separate.
You have to do a separate company, but if you are expanding your business, you can apply for that. You can say now our business has been extended, please amend our nature of business. You can do that. Yeah.
yeah.
We are a startup into design and manufacturing of drones. So in terms of IP, is it possible for us to protect a particular application in general? Like if we have a particular domain identified,
Yeah.
so can we protect that application or we can only protect the design of it?
Can you want to take it up?
Sorry, yeah, sure.
Can you, so for the drone, you're asking me about the design of the drone as well as
So
the
we have
technology?
designed a drone.
Yeah.
Drones are used in multiple applications.
Okay.
We are working on a specific application.
Okay.
So can we protect that application?
No. So application is not really a subject matter of patents or designs. So what you could apply for is the core technology that your drone is covering. Luckily, that core technology will cover any application. So it doesn't mean that you need 10 different patent applications, you need one. And in that patent, you must have it well drafted that it broadly covers only that core invention. And you may mention the application, but you don't even have to. As long as your core invention is protected, every application of it is protected. Yeah, I'll give you an example. Viagra, right? The pill Viagra, as we all know, was actually invented for a heart disorder, right? But its application picked up elsewhere. But the invention and the patent remain the same. Yeah, right?
Thank you.
Yeah.
How does the copywriting for online programs works? Online programs. Then there was
Cinematograph film, like media.
not a film, like a training program. With, training program which has multiple videos and it's a mix of written content plus videos, recorded videos.
Correct.
Yeah. And
So-
videos may have maybe slides, and images which may have been picked up from the internet, which may or may not be copyright protected. Right? So how does that propose?
There's a concept of public domain, my friend.
Yes.
Okay, mathematics, a teacher teaches, okay,
Fair
1 plus 1 is equal to 2. It's fair use.
Correct.
You can't protect it.
Correct.
Yeah, you cannot protect it. You cannot protect physics.
Correct.
How physics is taught, or how chemistry is taught, or how biology is taught. You can protect the content that you're making, which is innovative in nature.
Yes.
But you can't protect the teachings. Teachings is safe for everyone.
Understood.
Yeah?
Fair.
So idea cannot be protected.
Okay.
Expression of the idea
Expression of the
That
it done in a unique
can be
format.
in a unique format.
In a unique form, and that can be protected.
Understood.
There are various shows, music, singing
Like,
shows.
like a content like a Shark Tank.
Yes.
Right?
Mhm.
It's a format of a US based Shark Tank. Now nobody can replicate that in India. That's
Okay.
protected. That's expression and copyright.
Got it.
Right? Nobody can replicate that
Okay.
idea in India. Now the concept or the business in India. But teachings cannot be protected.
Got it.
Yeah.
Thank you.
It cannot be protected.
Just one more question. What's the legal validity of MOUs versus agreements?
So there is no concept of you to understand this. That heading of an agreement can be anything. You have to see the contents of the agreement. MOU is equally binding on the parties vis-a-vis any other agreement. So tomorrow, if you enter into an MOU with me that you will sell your land to me for an XYZ price on such and such days, it is valid.
Okay.
Until unless I am in breach of that MOU and then you terminate that MOU. That's a
Okay.
separate issue. Memorandum of understanding is a binding contract under the law.
But would it have to be registered?
Yeah.
So no,
For it to be
100
binding.
rupees or 500 rupees stamp paper is more.
But if it's not registered, if it's on
No, it
a
has-
doc and digitally signed,
So
would that be valid?
it has to be on 100 rupees or a 500
Okay.
rupees stamp paper.
Okay.
But if it's still not on 100 or 500 rupees stamp paper, it is still signed and you have acted upon it, then it's a valid contract.
Okay.
So let's say suppose I and you enter into a contract where I tell you that I'll supply you 100 tons of sheets of XYZ aluminium, right? It might be not registered. I have signed it digitally. You are sitting in US. You have signed it digitally, and I have supplied you 50 tons.
Okay.
You have paid me money for the 50 tons. Now 50 tons is remaining, and I am not selling it to you. Then you can sue me for that.
Got it.
Okay, because I have acted upon agreement, and so has you. I have delivered the stuff to you, and you paid the money.
Thank you.
That's a question.
Probably the answer would be same, but I still needed to actually confirm it. Can you protect methodology in the technology field, in the software, like the algorithm itself, and what takes in, what goes into algorithm?
Okay, so method patents are definitely protectable in India. Process, method, product, all under patents show. But when you ask me about algorithms, algorithms per se are not patentable because software per se is not patentable. The combination of a software and hardware is what you need for it to be a patentable subject matter. So I know you're asking yourself this question because you must have seen so many patents which are software related, and how do they do it? The way they do it is that, for example, let's take a calculator, the easiest, most basic. Without the programming that goes into the calculator, that hardware can't function. With this reliance on the software, you have a hardware that functions in a particular way. Therefore, that software is protectable. So if you have an algorithm which can make a hardware function in a particular manner, which the hardware cannot function otherwise, then that algorithm is protectable.
And the hardware itself need not be proprietary.
Not necessarily. Yes, it no. Correct. It could.
Like a mobile app.
Let me give you a more relatable example. A recently granted patent that we have is for a software which detects which detects hemoglobin in your eyes. You go to the doctor and the doctor pulls your eyelid down to see whether you're anemic or not. This software does it for you using your regular phone, right? Now the software basically has a system where it has a color mat, which is your neutral, and your color. It negates all the background noise and calculates the actual hemoglobin level in numbers, right? So this is a software entirely, but it has changed the function. Can a camera itself measure hemoglobin? No. But now with this software, a camera is being able to give you a hemoglobin. Now this has last month been granted. So this is what India is accepting,
That's the grant for the software or the particular device?
Everything together. So it would be the software which acts upon a camera. And that camera doesn't have to be on the phone, it could be any camera. Yes?
Thank you.
I have a I have a slightly different question. A very basic question. When I have an idea, when I approach investors for funding, what is the care that I have to take?
Non-disclosure.
So I have to sign with every investor when I talk about an NDA?
Very realistically speaking, you will not. As a lawyer, I'll tell you, yes, you have to sign an NDA, but realistically speaking, you will not be doing that. So I think we just discussed this, sending an email, right? It's on paper that you have told them that this is my idea and mentioning confidentiality note in your email. That is the most practical way of doing it, easy to prove with a date.
Ideally, if it's a technology.
Also, it can be done on WhatsApp, so it's okay. WhatsApp, it has an evidentiary value under the law. Whether on an email or a WhatsApp, so tomorrow you can go after them for breach of confidentiality.
But make sure to have the confidentiality.
And I should request confidentiality.
Just a little note saying this information.
Yeah, you should always have that.
There is always a disclaimer, you can put that.
We trust you will maintain this in the most confidential manner.
Ideally, in patents, for the technology aspect, you should first file and then approach the investor. If you are
it's an idea cannot be patented, right?
No, I'm not. So if it is a technology related aspect, and if you are very, before approaching, you know that it is a patentable subject matter. Apply for it and then approach it.
But what if it is not patentable?
So if you are, then it becomes a part of confidential information. Then you can record it in the minutes or sign an NDA. Please.
So I want to accept grants from, say, the US or Singapore into my company. So what are the laws that I should be aware
US or
of?
Singapore?
So US, Singapore, alright. So these are funds, I'm assuming?
These are grants.
Grants. So Singapore related grants.
And US.
And US, alright. So first of all, they have a lot of requirements. We recently had a client who was approved for the Singapore grant of 90 lakh rupees. And is that the same one that you're talking about?
It's a different one.
Okay, alright. So the license agreement, the grant agreement had a lot of requirements. For example, that they must shift their incorporation to Singapore, and that's one of the predominant clauses in most Singapore grants. So if you're okay with shifting base to Singapore, then that's fine. Other clauses are, much milder. But this I see as a big red flag in Singapore-related grants.
It's very expensive to even do compliances and Singapore laws. It's difficult. It's very expensive to even incorporate a company over there. You won't be based out of there. You'll have to have directors minimum over there.
Yeah.
Then you'll have to pay those directors their sitting fees on the board of the company.
Yeah.
Then compliances with their local registrar of companies over there. It's very expensive.
The grants that we are getting don't have such harsh requirements basically. They're willing to just wire the money. So are there any Indian laws that we need to look into to accept?
So India is fine as long as you are accepting the grant from foreign. That's fine. So that from a startup standpoint, it's all right. But I would still request you to go back and look at that agreement that you will be signing, because it's all in the fine print. So look at it. The Singapore grants, as far as I'm aware, have majority of them have this requirement.
Yeah, and if they have this clause of setting up in Singapore, and if you don't, then they'll come after you in India. They'll file a
You will have to return and just make sure. So things you want to check. In case of any breach of a grant, what is the penalty? Right? Because very often the penalty will be X amount plus interest. If that's the case, then you don't want to go ahead. If the penalty is within the grant amount, then make sure that you're ready to offer that amount back, because very often you would have spent most of it by the time it reaches a point of penalty. So when dealing with any foreign grants, this is very important to look into, especially US. US is more stringent about the penalty clauses, about breach, and about the dispute resolution. That's where most startups get caught up when they go for US grants. And Singapore's aim is more to bring startups to be incorporated within Singapore. So most of their grants will revolve around that aspect. Yeah.
Which is the one that you were mentioning?
I can't remember the name at the top of my head, but I remember the value was 90 lakh rupees. I'll get back to you with the name. Yeah. It was a very generic name. It was a Singapore grant, like it was a Singapore startup grant, if I'm not wrong. Yeah, it was something like that. Yeah.
In case of a flip structure, is there a minimum requirement in jurisdictions like US or Singapore that the company has to be there for a particular time until you decide on the reverse? That really depends on which grant you're going for. So, I can't really comment on US and Singapore laws, but as far as I know, the grants often come through states. So US is very state oriented, and every state has, they've got a lot of, the Georgia state has really nice incubation setup, and the grants are quite good. California is another. So their requirements are different. So within the country itself, states have different requirements. And Singapore, frankly, I don't know the base minimal number of years per se, but they do look at your certification in India as one of the, if you have been certified as a startup, they often ask that in the grant application. Yeah.
I have a question. If you can elaborate more about the POSH policy.
Sure.
Yeah.
All right. So the POSH policy has so Vishaka guidelines. I don't know if we have. Yeah. I see a lot of nods here. So the POSH Act is based on the Vishaka guidelines, and what it talks about is making provisions internally within the company for the victim to have a forum to go to in case of an incident of sexual harassment. Sexual harassment need not be as severe as rape. Sexual harassment could be very subtle. And what POSH really does is it requires the company to educate its employees so that the employees understand what sexual harassment is. Today, out of the many of us sitting here, you'd be surprised that, it's just that we come from a society where we don't feel comfortable discussing it, which is why understanding the subtleties of sexual harassment is very difficult. And which is the reason that we often don't realize when we ourselves are victims to sexual harassment. But we do feel uncomfortable, and very often when that happens, we tend to escape that situation. And that escapism often tends to be resignation, change of jobs, just changing the environment to get away from it. So explaining to people what sexual harassment is the first thing that Bosch requires within the company. So they require for training programs, they require for sensitization sessions, and a lot of what do you call these, posters and lists that are sent out, and your meetings, one-on-one meetings. It requires for what's called an IC committee. An IC committee is formed with 50% women and at least one external member, and somebody having knowledge of the POSH Act, or somebody who has enough experience, maybe working for an NGO relating to sexual harassment, or provisions for victims of sexual harassment. Now, while the Act is very gender specific, it only provides for relief to women who are victimized. Companies are free to have gender neutral policies, which is what we often draft, because the Act is not gender specific. So why should the regulations and compliances be? And with that, you have the requirement of an IC committee, training sessions, and sensitization through and through your company, your walls, your bathrooms, wherever your employees are working, so that they are made aware of what, first of all, SH amounts to. Number two, if such a situation happens, what do they do? You need to have a separate email address. That email address is to be circulated and informed to all of your employees, so that in case such a situation happens, they have a discreet way of calling for help. It also requires one senior female member of the company to lead the IC. And if at all it happens that the director of the company or any senior of the company is involved, they are asked to step out of all IC meetings. And the IC meetings happen in a closed, very discreet manner. They make sure they're required, the IC committee is required not to address it within the company at all. And if they think the act is severe, then they actually will help the victim take a legal stand, criminal stand, whatever. Yeah. So just, we can discuss further later. But yeah.
When it comes to the government initiative for grants and funds, what are the difference, grant and fund?
Okay, so a grant actually is no strings attached, and fund would be on conditions. For example, it could be a fund allocated for a low interest loan to a startup, or it could be a convertible instrument, as we discussed, or it could be on a reimbursement or based on a condition and with an interest, for example. But most grants will be either on reimbursement basis if you are able to show proof of expense, or they will be a rebate nature of grant. For example, you put in 20% and the government puts in 80%. Or very few, like the central grant of SISF, will be absolutely no conditions, no strings attached, 20 lakhs for you. Yeah, those are very few. Yeah. Yes.
This IT, what we find, are there different costs for Australia, US, and?
Oh yes.
And like what are the repercussions of both Australia is more stronger than US, and there are patents in India.
Yeah.
So just want to know the difference and.
Okay, it's great that you asked this question because IP is highly jurisdictional. So if you want protection in markets internationally, you first have to identify your countries where your markets are, and based on that, list out where all you need to file. Now, you will file the same application in all the countries, but you need to specifically enter into each of these countries. So if your markets are US, Singapore, Canada, for instance, and probably say add 2 more. So you have say 5 countries apart from India, and you first file in India, then you file what's called the PCT application. PCT is like your gateway to international filings. Why you need a gateway is because filing abroad can take time, although your drafting is done, although your your patent is ready, because identifying the right attorney, in case there is a translation required, negotiating fees, a lot of these things take time. So the international gateway, which is PCT, will extend your timeline. Within 12 months of filing in India, first filing in India, you must file at PCT, which will then extend that 12-month period to 30-month period. So then within the 30-month period, you must enter those specific countries. Until then, PCT will protect your patent in all the PCT member countries, which is over 140 countries. Yeah. So yes, individual. Every country is different, but the patent is same.
So within 30 months, you need to incorporate there, or?
No, you don't need to incorporate at all for IP filings. You could be anywhere in the world filing anywhere else in the world. Yeah.
So far as patents is concerned,
yeah.
Trademarks, then you have to go in every country. And there are different charges for every country. So, like India has 4,500 government fees and 9,000 for a company. There also there will be different fee structure. And there will be registered attorneys there. You have to then take assistance for that.
But incorporation in those countries is not.
No, incorporation
you can relate to trademarks and copyrights,
patents also.
So even the trademark filing is not required. Sorry, incorporation is not required for trademark filing in any jurisdiction.
No. You don't have to have incorporation even in India if you're filing it. You don't need to be incorporated.
In fact, trademark you can start using it in that countries, but it's always safe to first at least apply, and then start manufacturing. Because what happens is, like I give an example of the distributors taking advantage of. So you will be obviously having, if you are exporting a product to African countries, there will be a distributor that you will be hiring, a local distributor. You will be basically covering the territory. So most of the cases that I've seen in pharma and nutraceuticals, once the contract is over, okay, and if he sees potential in that particular brand, he registers it and starts manufacturing there and selling it there. So it's better to first, have a proper trademark protection there, because at least your proprietorship on paper is crystallized.
So a trademark filed in United States will be applicable in Canada and Mexico or North America?
No, it's again territorial. Every country you have to file a separate trademark application. So there is a Madrid, like PCT, there is a Madrid route also, where you can file from India and then enter into different designated countries through a single trademark channel. But we don't recommend it, because what happens is, if the application at the domestic level fails, all the applications in all other countries fail. So it's called a central attack.
And it's not the same with patents.
It's not the same with
Yeah.
patents.
If the Indian patent dies, you still have a valid application.
And what happens is, once you even go by the Madrid route, the examination then costs the same, because you have to hire attorneys there to process your trademark application. Instead, you just go the conventional route and target territories that you only want to go in African country or whatever, and you only file trademark application there. And slowly, when your business grows and you enter into different territories, then you can accordingly take that decision. That is why I said global strategy should be in place. How we want to go about it.
EU will have a common.
Sorry? Yeah, EU application is common. ARIPO countries is common.
But EU also, application of entry is common in patents, but entry further into EU comes with extra charges. So you do have to select those EU countries after approval.
Okay.
They are called the phase entries.
Yes.
In case of trademark opposition, do the government schemes cover the fees to fight against the third party?
No.
And Ragini, my question is to you. Earlier you mentioned grant expansion. What did you mean by the term?
So it's not that you expand that particular grant. What I meant is expanding your total grant that you get. So that can be done by strategizing your grants. Like I mentioned, SISF you won't be eligible for SISF if you have already received more than 10 lakh rupees from any other grants, right? So you better file for SISF first. So that's 50 in your kitty. After that, you can go to BIRAC. That's 50 more in your kitty. Additionally, you can go for your state grants. Maharashtra state gives 10 lakhs just for IP or general grants, right? So that's another 10 in your kitty. If you get a grant of trademarks, patents, design, you can add through MSME grants, which is given to granted IPs, as long as you can provide the grant certificate. So there are lots of, and there are multiple other state grants also. So there are lots of grants which, if you strategize well, you can get up to minimum 1 crore. That is what I meant by expanding them. But that's purely on strategy. Yes.
Just a continuation. Suppose I meet some big investor at a function or a party or wherever.
Yes.
So there, how do I take, and I pitch to him. So there, how do I take care of there is no email or WhatsApp?
Make sure that you have learned to explain your idea without giving the secret or the code. So, for example, if the invention I spoke about, which is the algorithm which tests the hemoglobin, right? So, if you told somebody that I have I have an idea, it relates to a software, and what it basically does is it tests your hemoglobin just like a physician. You haven't actually disclosed how. So you haven't really disclosed your patent, and patent is about how.
Have nice drink or lunch with him and then take it offline. That would work well.
Generally, it does the trick when it comes to funding.
One last question.
Yes.
So we do private limited registration for protecting against any legal cases where customers, they say that it limits the legal liability to the certain amount if some customer sues you and all. So can you give some highlights? Whether let's say I have an app and the data is breached, does private limited gives me some kind of protection? Or
you're talking about insurance?
Any app, right? It could be.
You're talking about litigation funding or insurance?
Yeah, right. So customer, if he files a litigation, okay, this app, because of this app, because the data was breached, I am in loss. So does private limited registration protect against that liabilities?
No, there is no protection as such, but there are definitely insurance mechanisms in media also that we do it very frequent. I think Nidish will be able to throw the net.
You can take insurances. Explain your question once again to me and give me an example.
So let's say I have an app, right, and I have your data. Now,
which data do you have?
It's your personal data. Your name, address, maybe your financial details. Now, let's say this app is breached tomorrow. Now, my understanding was at a very high level, private limited protects us against certain legal liabilities.
No.
So is that wrong?
No, that's wrong. Information Technology Act clearly says that every organization has to have reasonable protections and measures in place when you are taking people's data.
No, that's fine. That I will have. I will have key mechanisms. I will have security. But my question was, this private limited, what are those legal liabilities which private limited company protects us?
Civil and criminal both.
Okay. And,
compensation up to X crores of rupees, which will take years to prove in the court. And criminal case against you, where an FIR might get registered against you for getting the app breached. And because since you are the owner of the founder or the CEO of the company, so you will be held responsible for that. And you are managing the affairs of the company on a day-to-day basis. Both civil and criminal under the IT Act. It is covered under the Information Technology Act of 2008. Compensation up to 5 crores, if I may specify.
Yeah, that's very good.
Yeah, so you have to be very careful. You should be in a position to prove to the court tomorrow that you took every measures.
Right.
Technology is changing, my friend. Technology changes every minute. Okay, I mean, you have to be, if you are in the tech business, you have to be up to date. And that is where you need funds to be up to date. And that is where you need investors. You can contact Kushal for that. This time, huge network of investors over here. Thank you.
To what extent do cookies prevent, an organization? Because nowadays you are getting into a cookieless world.
Can you give her the mic, please?
To what extent do the cookies and the agreement to signing up on voluntary cookies prevent a company from the data protection or the data?
You can do that. There is no data protection law in this country. Bill is still pending. It's in US, which is there. It's the court's interpretation. When the matter goes to the court, it's the discretionary power of the court how to interpret that particular thing. So it's very difficult to say that.
Just to answer her question, if I may. Actually, cookies does not prevent data protection. It's actually taking data through your...
Correct. So, but I'm consenting, right?
Yeah, you're
if I'm consenting today to give that information...
you're consenting to the all except cookies wala option.
Yes. So if I have consented to that, tomorrow if the company is using that data in whatever manner, do I have any legit, case against the company if my data...
No, you're consenting into that. No,
but in an illegal way, that data is used in an illegal way.
Illegal way, then you will have it.
Like the act right now, because if the data protection bill becomes an act, then the sensitive data, if it is a sensitive...
This provision is there in that bill, that you are asking.
So if you are, you have or you are in possession of a sensitive data or a personal data, then the liability is much more. Then you will have to basically really preserve it, and there has to be a data audit, a data auditor.
Also, as long as you are informing, right, at the point of collection.
So you're safe.
And so the cookies is essentially doing that. Even the data protection bill says that you need to inform and you need to keep them informed as to what you're going to do with the data. So I think a lot depends on what the cookie says.
Yeah, and how your data is being used.
Yeah.
As rightly mentioned by Rahul, that's the most important thing.
But that is subject matter of evidence.
Yes, that
or we prove it or place it before the court of competent authority that it is used in the certain way. Like US Congress summoned all these big techie companies and the CEOs, and they were questioned. There was evidence before them that
it was used in a certain way, and they were questioned. Though it was not an adjudicating body, but it was before the public.
The law will come into the...
India में ऐसा नहीं होगा.
Ragini, tell me, can a Section 8 company access grants under DPIT?
It can. We have one Section 8 company that is currently applying for a couple of grants. In fact, Section 8 company, beyond its CSR, beyond the grants of, it can have even facilitation grants, and it can have a lot of other government grants, but it needs to, have, so if you're asking about PPT grants, no. So the requirement, as I said, of incorporation is what comes into the picture here. And there we don't, when we are applying for the certificate, we don't get an option to mention that we are a Section 8. But it is eligible for a lot of other grants, yes.
But Section 8 is either a private or a public, right? So
yeah, so there, if you know, her question is specifically as a Section 8, right? Now, then going back to whether that is a PVT LTD, yeah.
Okay, it could be a trust as well.
Could be,
from that perspective.
Yeah.
Okay, that just went over my head, but I will ask.
Yeah, so basically what if to put it briefly, regardless of Section 8, if you are an LLP, if you are a PVT LTD, if you are you can get the DPIIT certification. Okay. So long as you have complied with the DPIIT regulations of being under 10 years, of solving a problem, of being under 100 crores.
So Section 8 company is different from...
No, if it is a Section 8 company.
No, the problem is there are a lot of Section 8 companies, till you don't have a 3 to 5 year track record, you don't get easy funding. That's the big bummer.
Correct, that's true, the 3 year
threshold. So it's just a big barrier to entry.
That's
right.
So you also have a package, you were saying, for startups?
For startups, yes.
Do you have any information on
We
that?
don't have anything here. We're happy to share it. You can just drop me your email and we'll send you across the package.
You should send a consolidated
Just to,
email.
sorry?
You should send a consolidated email to everyone on this group with
Yeah.
that package because
Would you all be interested? Okay. Sure, we'll send across our package to all of you. If you could please be sure to drop in your cards in the glass bowl there. We'll be sure happy to send you.
They've already given the names.
Oh, you've given everything in the form, so then that's
details.
They have, I have the data.
okay. And also, we have separate packages for corporate and IP. So, which package are you all looking at? Okay, all right. Okay.
We'll give you all the benefits. With goodies.
By discount.
You also
We'll
help
negotiate the
grants.
discounts later.
You also help in securing grants.
Sorry?
Grants.
Yeah.
Yes, we do. Yeah.
All right. Thank you everyone for coming. Thank you Rahul, Ragini, Nitish. Please block your calendars for TiECon. It's 1st and 2nd of June. Yeah. So block your calendars from now. We'll send out an email, a registration email to everyone in which ways. But just keep blocking. Just block your
Are you from Thai?
Yes.
So I have a question. All the other Thai members, at least Delhi is so active. It's great to see you organizing something in Bombay. Can we see more events between now and June? Webinars or something? I mean, come on.
Webinars are happening.
They are?
Yeah. You might not be getting email, but they are happening.
Interesting.
We kind of have like 4 to 5 events per month.
All right.
So
I think
you'll
following all the
see a
Delhi
drop of
ones.
events after April.
Okay.
Because then we'll be busy with TiECon. But till April, still the 4 to 5 events per month will be there.
It's in Mumbai, right? TiECon. You're organizing the TiECon in Mumbai.
Yes, it's in Geo.
Oh.
Yes.
When is the next meeting?
So once you go to the Thai website, now you see upcoming
When is
events.
the next
you see
meeting,
everything.
Mr.?
Because I get Delhi and I became a Mumbai
March of
member. I mean, I became a
16,
Mumbai
15th or 16th. You get an
This
email.
month.
We are still discussing with the
But if you go
It
to
will be with our
Thai
ventures.
page, there is events and it has everything.
Every month. Thank you everyone.
Thank you.